Hi there, thanks for joining us. In this video, we're going to be talking about how you go about applying for Canadian permanent residency on humanitarian and compassionate grounds, H&C. All right, so please stay with us. We'll have much more on this after the break. As always, remember to like our videos so others may see more videos like this. Subscribe to our channel so you will be notified when next we publish a video like this. And check us out on our website at go.gooselaw.com. I'll be right back. Hi there, welcome back. My name is Donovan Francis and I'm a Canadian immigration lawyer, and I help skilled workers, families, businesses and students with their Canadian immigration matters and save them from having to deal with complicated immigration rules. In this video, I wanted to quickly talk about the Canadian humanitarian and compassionate application option for persons who are wanting to become Canadian permanent residents but who do not otherwise meet the requirements of the regular immigration permanent residency options that the Canadian government has made available. So persons who want to become Canadian permanent residents, they have multiple options. You know, they have options to come under some of the economic programs. They can come as skilled workers. There are provincial programs that allow people to become permanent residents. And there are also options that allow for Canadian nationals to sponsor certain immediate family members as well. So there are many options available to non-Canadians who are wanting to become permanent residents. But there are instances where a non-Canadian may not meet the requirements in order to apply for permanent residency under one of the regular programs. Or there may also be instances where a non-Canadian may not be admissible to Canada, may be inadmissible to Canada for a number of reasons. You know, reasons such as they might have had a criminal history, or they might have had a serious medical condition, or they might have had a previous issue with Canadian immigration, all of which could potentially render them inadmissible to Canada. And so where somebody is inside Canada and that person is ineligible to apply for permanent residency under one of the regular streams, or where that person is inadmissible, the option of last resort that may be available to that person is to submit an application for Canadian permanent residency under humanitarian and compassionate, or rather on humanitarian and compassionate grounds. Now, ordinarily, persons, foreign nationals or temporary residents who are here inside Canada are not allowed to apply for permanent residency unless they meet one of the stipulated options that are available to persons in those categories. However, this exemption exists for persons who would not otherwise be eligible, as I've indicated before, to submit applications on humanitarian and compassionate grounds. Now, this is a very specific type of application, and in order to successfully apply, you must be able to show that your situation in Canada fits into one of the designated H&C factors. And we're going to be going through these in details to help you understand whether or not you are likely to have a strong H&C claim if you are a foreign national who is, or rather somebody who is inside Canada temporarily and who is looking to apply for permanent residency but is unable to do so under one of the regular channels. Now, it's important to note that not everyone qualifies. There are some persons who may be inside Canada who might not qualify. For instance, some persons who've had their refugee applications refused, for instance, may not, under certain circumstances, apply for an H&C application, or if you already have an H&C application on the way, you can't then go ahead and submit another one, and so on. So there are some circumstances in which persons would not qualify for H&C applications. But in situations where one is generally eligible to apply for an H&C application, there are certain factors which would come into play when determining whether or not you are going to have a strong H&C case. All right. And so when we are putting together an application on H&C grounds, for instance, we want to make sure that the person on whose behalf we're applying meets as many of these factors as possible. Okay. And so one of the crucial factors is showing that the applicant is established inside Canada. And when we say established inside Canada, we mean that the person has been here long enough to have created some kind of ties to Canada, you know, whether it be through their employment and whether it be through their financial situation. Have they bought a house? Have they rented a house? Have they been living here for a substantial amount of time? Are they in a job? Have they been in that job for a while? Are they contributing to the Canadian society in a meaningful way? You know, are they established in terms of their community involvement? Are they involved in the community? Are they involved in any kind of volunteer organization? Do they go to church? Do they contribute to the community in a meaningful way? All of these factors will help to show just how well established this person is in Canada, and that's going to be a crucial factor when determining the strength of an H&C application. Okay. If there's a situation where there is some factor that's causing the applicant difficulty in leaving Canada and which ultimately led to the establishment, that needs to be taken into consideration as well. You know, we've seen cases, for instance, where a non-Canadian came here and they had to be assisting their Canadian relative who was ill. You know, and that led to them being here for much longer than they initially anticipated and becoming ultimately established here in Canada. So you want to talk about factors like that. Other people may have gotten children while they're here, and that then makes it more difficult for them to leave. And by virtue of that, they then would have created an establishment inside of Canada. And so ties to Canada, that also is connected to establishment in Canada. You know, are there family ties here that would mean that the applicant, it would be in the applicant's best interest to remain here? You know, do they have strong ties here? Are there relatives here? Are there immediate family members who are Canadian permanent residents or Canadian citizens? That is going to play a factor. Another crucial element when evaluating and putting together these applications is the principle of best interest of the child. Okay. Now this is a legal doctrine that in Canada's laws, including Canada's immigration laws, the impact of a decision on the child of the applicant does play a part. It's an important factor in helping the authorities and the courts, where applicable, make their decisions. And so the best interest of the child is going to be a factor. This is particularly useful where there are Canadian-born children in the case, but it also applies in situations where the child might not have been Canadian-born. You want to explain how it would not be in the best interest of the child for that child to be removed from Canada and returned to his or her home country. So if that child has been here for a couple of years, for instance, they've become established in Canada, they've been going to school, they have friends, they're integrated into the school system, to then uproot that child and have that child forcibly remove that child from Canada along with his or her parent would not normally be in the best interest of the child. And so that's the case that would be made in this instance. And so if there is a child or if there are children involved, then that makes it stronger. It creates an opportunity to make a stronger argument that you be allowed to apply for permanent residency on humanitarian and compassionate grounds, because it's going to be in the best interest of your child that you be allowed to do so. Okay, so that's a strong argument, and we'll expound on that a little bit more. Family violence considerations, if there are issues of family violence, especially in your home country, and if there's a risk that being asked to return home could potentially lead to all kinds of violence and harm to yourself and the child, that potentially could be taken into consideration. So too would be the consequences on any relatives you have in Canada, especially if you have Canadian relatives who are citizens or permanent residents. That too is going to be taken into consideration. Factors in your country of origin. You know, if there's going to be undue hardship in your country of origin, should you have to return there, then that's a factor that would be taken into consideration as well. And in addition to those, we also look for any other factors that potentially could be taken into consideration when an application for humanitarian and compassionate ground is being submitted. So those are all important factors. And just to expound on the best interest of the child, again, it's a crucial factor in these kinds of applications. And some of the considerations, some of the things that will be taken into consideration is the age of the child. If this is a relatively young child that's very dependent on the applicant, then that's going to be an important factor, as opposed to a situation where the child can take care of themselves. The child is independent of the person. So the age of the child does have a role. The child's establishment in Canada. Has the child been here long enough to have created some kind of a bond and some kind of ties to Canada? You know, has the child been going to school for an extended period of time? Have they developed friends? Are they used to the school system? All of those factors are taken into consideration when exploring the best interest of the child factor. Again, the conditions in the country of origin, if the child were to be returned there, if the child has a serious medical condition, medical situation, those are factors to be taken into consideration, as to would the child's education and the child's gender. You know, the gender of the child matters. If the applicant's child, if the applicant is a mother with a female child, a young female child, then that may be a crucial matter in an application of this type. So those are some of the factors that are going to be taken into consideration when a decision is being made on an application for permanent residency on H&C grounds. And these factors relate to situations where persons are inside Canada and are applying for permanent residency under the H&C grounds from inside Canada. Do bear in mind that there's also an option for persons outside Canada who are wanting to apply for permanent residency to do so on H&C grounds. But for the purposes of this video, the focus is on persons who are already here and who want to apply for permanent residency on humanitarian and compassionate grounds. So I trust you got some value from this video. And as always, remember to like our videos so others may see more videos like this. Subscribe to our channel so that you will be notified when next we publish a video like this. And always remember to check us out on our website at go.gooselaw.com. Thanks. See you again.